This video is a broad outline as to what you can do if your friend won't give your dog back. Sadly, it is an increasingly common occurrence where if people separate or friends move out, that they take the pet with them. Very often there will be a disagreement as to who owns the dog or the cat or any other pet and who is to get that pet when couples separate or when friends move out, and ultimately this can end up in a very difficult situation for everybody concerned. Ordinarily, domestic animals are considered to be part of the family, and most people don't think of them as any kind of property, as you would a mobile phone or a laptop. So this is why the law is worth explaining and to give you some guidance as to what to do if your friend won't give your dog back and has taken it with them and is simply refusing to discuss it or to cooperate. But first of all, if you're new to my channel, I'm a barrister who helps you understand law, so make sure you hit the subscribe button and the bell icon and then you won't miss out on anything. You can also check out courses that I'm launching at BlackBeltBarrister.com, and you can pose more questions that I will answer on my sister channel, Black Belt Secrets. So in this video, I'm going to give you a broad outline of how the law deals with such a domesticated animal and how you might approach a claim if you want to get your animal back. The starting point is that when it comes to ownership of said animals, whilst there are other implications in legislation such as animal welfare, the law treats an animal in the same way as any other kind of property, or chattels as it's known in law. Just like any other kind of property, ownership of animals is absolute, whether that is in a single name or a joint name. Obviously, it gets to be much more difficult if there is a joint ownership of any kind of property, but that we're going to come back to. But first of all, a couple of areas that don't really fit into the rest of the video. So taking a dog as an example. If a dog has strayed away and then someone else takes the dog in and effectively tries to take ownership of that dog, the original owner will still retain ownership because ownership is absolute. There is no transference of ownership just because the dog strayed away and someone else took that dog in. However, if that person has spent any money on the dog, such as vet fees and costs of food, they will be entitled in most circumstances to reclaim that money because they've spent the money on the dog. Although it is also right to say that they cannot just hold on to the dog pending payment of that money. They should be giving the dog back and then making a claim for the money if that's what they want to do. So back to the typical scenario of where two parties are generally arguing about whose dog it is. One person will typically be saying that the other person has wrongfully retained the dog and it belongs to him or her. These sorts of cases are often heard on the small claims track. Now, whilst the small claims track is typically reserved for monetary claims not more than £10,000 and various landlord-tenant claims and low-value personal injury claims, the county court will often allocate these types of claims to the small claims track because effectively it is for one party to show ownership of said animal and the court will make a determination. Of course, there are cost implications on the small claims track for which you should seek formal legal advice if you are in any way unsure. Typically, it means you cannot reclaim your lawyer's fees if the case is allocated to the small claims track. Essentially, what the claimant would be seeking in such a claim is a declaration of ownership under the Torts Interference with Goods Act. If the claim is successful, the court would be able to make a declaration that the claimant owns the dog absolutely and an order for the other person to return it. The court may also consider an award for damages for the wrongful retention of the dog if that is the finding of fact by the court. However, it is important that I emphasize that this is a discretionary remedy of the court. In other words, even if the court finds in your favor, the court is not bound to make such an order that the dog is returned. Some of the things that might impact whether the court makes this decision is how quickly the claimant acted in dealing with the issue. In other words, did they write to the other party straight away? Did they seek representation from a lawyer straight away? And how quickly they filed a claim if the other party unequivocally refused to give the dog back. These are some of the elements that will need to be shown. In other words, the claimant will need to show the court that there was an unequivocal demand for the return of the dog from the other party, and that this was made without unreasonable or undue delay, such as 6 months or 12 months before taking any action. That might defeat a claim, and I'll explain why in a moment. The second thing the claimant will need is an unequivocal refusal by the other party to return the dog. This need not come in any particular form. It might be by a phone call, in which case you would document when the call happened, what was said on the call, who was present, and so on. if at all possible, the precise words that were used and make a note of those words. Ideally, however, you would have a text message or a letter or an email or something else which is in writing, unequivocal, unquestionable refusal to return the dog, in which case you are justified then in bringing the claim in court. All of which is going to be a matter of evidence, which I'm going to come back to a little later in the video. But first of all, explaining, as I said, why avoiding delay is important. That is because whenever there is a discretionary remedy at large in court, it is important to show that you have been fair and acted fair and reasonably in all of the circumstances. In other words, you need to act fairly and politely, however upset you might be. It is important not to show anger and frustration if you can at all help it. It is also important not to make any kind of threat, unless of course it is a justified threat of litigation. In other words, you will have no choice but to initiate court proceedings if they continue to refuse to return the dog, but any other kind of threat should absolutely be avoided. Also, there is a principle in law known as equity. Equity you can think of as being fairness. There is also a maxim or saying that goes, delay defeats equity. In other words, if you take a long time and have a long delay before doing anything about this issue, whether that be writing to the other party or issuing the claim in court, this might defeat the equity, the fairness of your claim. In other words, it might be unfair for you to bring a claim 12 or 18 months down the line if you haven't already addressed this with the party in the interim period. Other options that the court might order is that ownership of the dog is shared and therefore the dog should be between two households, which is often a difficult thing to do, but it would be for the parties to persuade the court or indeed agree that this is a fair resolution. And as a last resort, in theory at least, the court could order the sale of the dog and that the parties share the proceeds, although I think this is relatively unlikely. And now on to actually arguing your case in court. These are the kind of things that the court is going to want to look at when determining ownership of the dog and who has the best case as to who owns the dog when trying to persuade the court to make such a decision. One of the most obvious arguments is if one party already had the dog before they came into the relationship or before they moved in with a roommate of sorts. If that person owned the dog long before that relationship began or long before parties moved in together, then it is much more likely that the court is going to believe that it is that claimant's dog and not anyone else's and should be returned to its owner. On the other hand, if parties were already together, whether that be as a couple living together or just roommates living together, and there was a joint agreement to purchase a dog as a family or household pet, then it is very likely in those circumstances that the court is going to make a declaration that there is joint ownership of this dog. In which case a different argument will need to be run as to why it is more ideal for the dog to live with the claimant than it is with the defendant. The court may ultimately make a decision. As I said, this is a discretionary remedy of the court, and the court is going to take all of the facts into consideration. Other things the court is going to look at are quite literally and logically who purchased the dog, whose money it was that was used to purchase the dog, whether there was a written contract, ideally if there was a kennel breeder who entered the claimant's name on the ownership documents of said dog, if there was a kennel club and the claimant registered the name with the kennel club as the owner of said dog, whether the claimant was registered at the vet's practice as the owner, whether the claimant was registered on the insurance documents as the owner, whether it's the claimant that pays for all of the expenses for the dog, such as the food and vet bills and these sorts of things, together with who is the regular carer for the dog. In other words, who spends the most time with the dog, who is taking the dog for walks. All of these kinds of things are evidence that the claimant can show that it is really their dog, and the court should make that declaration in their favour. And now on to actually dealing with the claim. It is absolutely crucial that every order of the court is dealt with appropriately by the deadline and both filed at court and served on the other party. Failure to do so may result in the claim being struck out or indeed a defence being struck out if such an order is not complied with. Although on the small claims track there is sometimes a little bit more flexibility with these things, this is particularly important when it comes to filing your evidence. Now you see, it is very important to understand that filing a claim is one thing. This is your statement of case. This is stating your claim to the court and to the other party so that both the court and the other party understand what your claim is. A lot of people confuse this claim stage with evidence that you want to file with court. Sometimes, in fact, lots of people will file all of their evidence with the claim in the first instance, thinking that that is the entirety of what they need to file in court and serve on the other party, and in fact they omit or leave out any further evidence in the form of a witness statement and supporting evidence that should be filed with a court at a later stage. This is why I emphasize it is crucial that you look for these deadlines, because the court is quite likely to tell you a date by which, usually 4 p.m. on a given date, that you must file and serve witness statements that you intend to rely on in court. That might just be yourself as a claimant or as a defendant. It might also be someone else. For example, if there is more than one person living in the household that can attest to one party or another's case, they might well be called to give evidence at the hearing, each of whom must file and serve a witness statement in the proper format with a statement of truth at the bottom, underpinning it with all of the evidence upon which they intend to rely, so that when it comes to the hearing, both the court and every other party has a copy of the witness statement and the evidence that you wish to rely on, so that either you or your legal representative can present your evidence to the court and to cross-examine any other party on their evidence as to why your case should win over theirs. And for a little bit more information as to how a barrister approaches a case like that, I have another video already prepared coming out later this week, so make sure you subscribe and look out for that video if you want to see that as well. And finally, it's worth mentioning that in addition to a claim for a declaration of ownership and return of the dog, you should also usually include an alternative claim for conversion. The claim for conversion will therefore be for a sum of money in the event that the dog cannot be returned, or indeed that the court refuses to make an order that the dog is returned. So more generally, as I often say with any type of claim, evidence is key, and you need to find as much supporting evidence as you possibly can. One of the most common mistakes that I see with litigants coming to court is that they do not dig up the relevant evidence at the time. Now, there is a specific rule that if you come to court and you don't get a decision in your favour, if you wanted to appeal that decision, you will not be able to rely on any new evidence that wasn't before the original court, if such evidence could have been obtained with reasonable diligence the first time round. In other words, the court isn't going to entertain the idea of everybody coming back to court to have the same argument again, because now you've realised what evidence you should have brought in the first place. So my guidance is you absolutely must have all of the evidence that you intend to rely on at the court of first instance. That is the first time that your claim is properly heard in court. So please do give this video a thumbs up if it was useful, and apologies if this video was a bit late. I did mean to get round to this a lot earlier than I did, but in the meantime, remember, stay humble and subscribe.